All right, now we're joined by Sheryl Gordon McCloud, who's running for Supreme Court Position 9. So go ahead with a 2-minute introduction.
Greetings, thanks for having me. I am Sheryl Gordon McCloud. I am a justice on the Washington Supreme Court, and I was elected in 2012, and I know I'm here in part because of your prior endorsement, which I thank you for, and I'm proud to be a justice on the Washington Supreme Court. I say that because the courts, I think, have been under attack recently as jokes or a laughingstock. And I want to say that I'm a proud member of the judiciary, and I think our court has taken strides to recognize constitutional rights, recognize individual rights, and use our administrative and rulemaking power to take care of other problems, like the problem of continuing race discrimination in jury selection. I have been a leader in all of those things. I was the author of our court's Arlene's Flowers decision, which dealt with the right of a gay couple to go into the florist of their choice, and we held in a decision that I authored that they had that right, the same as a black couple has the right to go into the luncheonette of their choice. I think my work on the court has been characterized by hard work, intellectual work, listening, and a respect for constitutional rights and individual rights. And my keywords for this campaign are judicial independence, and judicial independence. So I welcome your questions.
Great, thank you. So now we have our 4 prepared questions that we're asking all candidates for Supreme Court. And they're right in front of you if you want to turn the piece of paper over and read along as we read them aloud. And David, would you read number 1?
What do you think were the top accomplishments of the recently completed term of the court?
Well, in terms of administrative matters, I think our adoption of GR 37, General Rule 37, having to do with jury selection and whether blacks and other people of color could be bumped off of juries, was one of our critical accomplishments. It had been in the works for 2 years. It was hotly debated, and we took the time not just to publish the draft rule, and receive all the comments on the draft rule, but then to send it to a separate committee of different stakeholders to convene to further discuss it. And among the stakeholders, of course, were the judges in our trial courts, superior district and municipal courts. And while they didn't reach unanimity, they did come to us with a recommendation, and I think we were able to achieve a lot of agreement on that. I think that was a singular accomplishment of our court, and is one of the first in the nation to try the rule that we're trying. So wish us all luck. In terms of the cases from the last term, let me talk about the last year, because it's hard for me to separate out what was just last term, and many of them have not yet been published yet. But I do think that our accomplishments for juveniles have been terrific. We have applied constitutional protections, particularly the 8th Amendment, to juveniles, and given trial court judges the discretion that the Constitution vests in them to give children child-sized sentences rather than adult-sized sentences. I think the decision that I authored in State versus Houston Sconyers was one of the key decisions of that in that genre.
Ben, number 2.
Please share an incident or aspect of your work history that has changed or enhanced your interpretation of the law.
Well, you know, I started out as a public defender in Seattle at the Seattle-King County Public Defender Association, and that work involved, by definition, representing people who had no funds to represent themselves. And I was in misdemeanors and felonies. I represented a large share of people of color, and I think it informed my understanding of how the law has, facially neutral though it may be, has different effects on people with money and people without money, and blacks and other people of color. And it was one of the things that it comes out in Fourth Amendment right to privacy issues, in who the police stop, in the types of sentences that people of color receive, in which cases go to federal court with more draconian, in my opinion, sentences than who stays in state court. And I think that history of working at the Public Defender's Office informed a lot of what I brought into private practice and my dedication to continuing to do pro bono work after I hung out my own shingle and started my own law firm in 1990 because the need was so great. So I guess that whole experience of about 2 or 3 years at the Public Defender's Office was critical in my development.
Jason, number 3.
Please describe your belief around the concept of restorative justice and whether you see a potential for judicial action from the bench as influential on that process.
Well, our country has one of the highest rates of incarceration, according to an article I read yesterday, the highest rate of incarceration of any country in the world. So restorative justice is not something that we have a lot of experience with. And in my opinion, it's something that, well, we're in desperate need of a move away from the policies of the last 35 years, which resulted in an increase in incarceration, particularly of people of color, but also resulted in the fact that women of all sorts are the portion of the population whose incarceration is increasing the most dramatically. Therapeutic courts, diversion away from charging from court, diversion away from court completely, treating juveniles as juveniles, and also the concept of restorative justice, I think are alternatives that we definitely need to consider. Many of those the judiciary has taken on without legislative intervention. For example, therapeutic courts, veterans courts, and drug courts. Restorative justice, and we the court are just returning from the Colville tribes, the Confederated Colville tribes, where we sat and heard arguments on Tuesday, and we also learned about a lot about their circles, their restorative justice circles that they're trying there, and that they're teaching to other people to try as well. So I think in our state, the judiciary has an open ear to alternatives to punitive sanctions as the only form of justice.
And Sophia, number 4.
If elected, do you have any specific priorities for the court's next term?
Well, we take the cases that come to us, so I can't tell you that I'll pick and choose a terrific case that I'm really interested in. But I can tell you that my priorities have to do with poverty and with race. So I'm chair of our court's Gender and Justice Commission. We've just submitted a grant for funding for a 30-year look back at our courts in the state of Washington to see how we're doing on gender issues. A report was issued 30 years ago that with limited funding and looked at a few specific areas, divorce, rape, domestic violence, and some consequences in civil cases. We are taking a far broader view when we get, knock on wood, when we get the funding, to look particularly at poverty and race and how women who are served by our courts are treated by our courts. So that's one way that that priority is being achieved. It has a lot to do, the other ways that those priorities can be achieved have a lot to do with funding for the courts. Funding programs, for example, child care centers is an example, that would enable more women to come in and serve on jury duty, that would make it easier for women litigants and witnesses to come in. I applaud our Chief Justice Mary Fairhurst, for the letter that she sent out in this last term, expressing our concerns to the Secretary of Homeland Security about immigrants who were being targeted at courts, and explaining how that particularly targeted women who were witnesses in domestic violence cases. So those issues of race combined with gender and poverty are all in the back of my mind and inform the areas of work that I would like to take on. But the cases that we take on, we're the receptacle. The cases come to us and we just decide which ones fit our criteria for review.
So now we'll open up to follow-up questions. These are 1-minute answers. People can ask whatever they want. And we will start with Ben and Jason.
Seattle prosecutors are seeking to vacate more than 540 convictions against people caught carrying small amounts of pot before legalization. Would you support the spread of this throughout the state?
Well, you're asked, great question. I'm familiar with Seattle's process of seeking to vacate those convictions basically through the newspapers. We haven't seen a case on it yet. I don't know of any controversy on it yet, which is the way that the case would get to us. As a practical matter, since I want to see the stop in mass incarceration, and since a lot of it has occurred in the area of drug arrests, I think it's a positive step. But I think whether it should be duplicated in other areas of the state is, first of all, a question for the elected prosecutors in other areas of the state. My read of the newspapers is that that's who made the decision to go into court here. And my understanding is that they did it with support of the executive, Mayor Durkin, in this city. So I think it's also a question for the executive in those other localities. Any steps towards reducing the collateral consequences of incarceration, I think is a good step. But whether or not that's duplicated in other parts of the state is not up to me. It's up to the prosecutors and the executive in those areas.
Thank you.
I'm going through the, kind of like a follow-up question, I'm going through the process of getting 4 expungements, and cash punish, let go, and repeat is just not working. And 20 years down the road, where do you see our justice system going?
Well, I think it needs some drastic changes, and there's probably 2 paths that it can go down. The path that I don't want to see it go down is underfunded, not able to serve people, not able to welcome people into the courts. I think the path that it needs to go down is to be more responsive, to acknowledge that a lot of people can't actually come in to court because they don't have a lawyer, and we need to provide those people with some sort of legal help, either free or low-paying lawyers, or information more available on the internet. But without a change in making the courts more accessible, it's going to be out of the reach, remain out of the reach of a lot of people, and that won't be good for anybody.
Thank you so much.
Additional questions? David?
Yeah.
Do you have an opponent?
No, thank you for asking. Filing week, as you know, is next week, May 14th to 18th. At this point, nobody has declared against me, nobody has filed against me. I have not heard any whispers about anybody running against me. I started out strong in January. I wanted to make sure that there were no opponents. I got the endorsements. I started my campaign manager on her fundraising process. We've been to union groups and business. We've been to legislative districts. We've been to women's groups. We've been to all kinds of groups, and I am getting the endorsements, and I'm quite hopeful at this point. But if you're gonna run, you better run scared. So that's what I've been doing.
If you end up with an appointment, I mean, you've put together a spectacular list of endorsements
Thank you.
and a campaign committee. But I'm looking for a URL on your stuff here. I mean, if there is a campaign, there we go. This is how we reach you if we want to volunteer,
Yes,
contribute, all of
thank
that.
you. Website is right on there.
Yeah, I was just having trouble finding it.
Yeah,
Okay, so
we'll make it bigger next time.
we'll figure that out if the time comes, but Nicole, do you have another question?
Who are your judicial role models and why?
You know, I clerked for a judge named Warren Ferguson, 1984 to 85, the year I graduated from law school. He was Ninth Circuit Court of Appeals judge. And although I know it would be more accessible to a lot of people if I gave a name that you knew, the truth is that when I went and clerked for Judge Ferguson, he sat the clerks down and said, now, you know, our complex commercial cases are given a 10 weight, considered the most weighty, to be given the most time to, and those Social Security Administration appeals, they're given a 1 weight because they're considered simple and straightforward. I want you clerks to treat those Social Security Administration appeals with the same care that you treat any commercial litigation dispute that comes in here, because that's the most critical case for that person who may be deprived of benefits. And I just, I hear those words in my ears as a judge, and when I get clerks and externs in, I have to remind myself that I might be the role model, and I've got to present it just like he presented it to me. So.
Additional questions? Time for 1 or 2 more.
Do my other one.
Sure, why don't you do your other
Okay.
one, Nicole?
Okay. What do you do in your court to promote victim safety?
To promote victim safety, well, through the Gender and Justice Commission, we have a domestic violence and sexual violence committee that's working on some of those issues. Specifically, they do education of judges and lower court bench in terms of how to treat victims. Our Chief Justice, as I mentioned, wrote the letter to Homeland Security about ICE enforcement at the courts and how that was in some areas perceived as deterring victims from being able to come into court as witnesses. Those are the main vehicles that I personally am involved in.
David, you have one more?
You think that the legislature has properly fulfilled the demands and requirements of McCleary?
So the question you've asked is whether I think that the legislature has fulfilled the demands and requirements of McCleary. That is a question currently pending before the court. We gave them a deadline of the 2018 legislative session, which has ended. We've gotten in the briefs of the parties. The next step is for the court as a whole to make a decision. So that is a particular area that I cannot make a decision with you about in advance of my discussion of that with the court.
Thank you.
Thank you.
All right, so we are about out of time. If you want to take 30 seconds for a closing statement.
Well, I thank you for your questions. I thank you for your concern about women, about victims, about poverty, about the consequences of mass incarceration and how long those consequences follow people. I am concerned about the exact same things, but I think concern about our judges being able to act as judges without fear of criticism or intervention from other branches of government, and without fear of what the majority thinks, whether they like or dislike our interpretations of the Constitution, is really key for all of us to be involved in to achieve some of those goals. So, thank you.
Thank you very much.